Chapter 1. Fidelity Bonds. Section 1. Scope. In a broad sense, all bonds with surety may be said to be fidelity bonds, in that they guarantee the fidelity of the principal in the performance of a duty or obligation. In the sense in which the term is here used, and in which it is generally used by surety companies, it embraces only bonds given by private employees to protect their employers against loss on account of their infidelity. The term private employees is here used in contradistinction to public employees or public officers, but where the clerks employed in a public office are not required by law to give bond, but do so at the request of and for the protection of their superior, who, under the law, is liable for their defaults, the regular fidelity bond is generally used, so that the risk of the surety is the same as if they were private employees. In this chapter, therefore, I shall deal with the bonds of all private employees and such public employees as give bond, not to the state in compliance with law, but to their superior, who is liable to the state for their defaults. Sec. 2. The liability under fidelity bonds. The ordinary fidelity bond does not, as its name would probably imply, guarantee the fidelity in all respects of the employee, that is, it does not guarantee the full and complete faithful performance of his duties. On the contrary, the bond ordinarily issued by surety companies is limited to cover loss resulting only from certain specified acts on the part of the employee. In the earlier days of corporate suretyship, it was deemed prudent to protect the employer only against such loss as might result from acts for which the employee could be criminally punished, as the fear of punishment was, and is, regarded as a very strong incentive to honesty. Accordingly, fidelity bonds generally covered only such loss as might result from acts amounting to larceny or embezzlement. It was found, however, that some courts and many employers construed a fidelity bond to be a guarantee that the principal would not wrongfully and in bad faith misappropriate the employer's money or property, and it often happened that bonds, which by their terms covered only larceny and embezzlement, were liberally construed in favor of the employer, with the result that the surety companies were held liable in many cases where the employee escaped criminal prosecution. At a comparatively early date, therefore, some of the companies began to issue bonds expressly covering all loss resulting from fraud and dishonesty on the part of the employee, and most of the other companies soon began to do the same. Recently the companies have been issuing a still broader bond, covering also loss resulting from forgery, misappropriation, wrongful obstruction and willful misapplication by the employee. It is doubtful, however, if these words actually broaden the liability, as any such act would probably be dishonest or fraudulent. The essence of the risk under almost any form of bond is the chance that the principal will wrongfully and in bad faith misappropriate the employer's money or property. Sec. 3. Termination of liability. It was stated in the introduction that as a general rule bonds with surety could not be cancelled by the surety before their natural expiration. Fidelity bonds are an exception to that rule. They are private contracts between the employer and the surety company, and the parties may agree upon such terms as they see fit. And it is entirely consistent with the nature of the obligation that the surety should be permitted to terminate the liability for the future acts of the employee, as the employee may at any time be discharged without seriously affecting the rights of the employer. Accordingly, these bonds usually contain a provision for termination of liability upon 10 days' notice, the surety remaining liable for any breach of the bond that may have been committed prior to the expiration of that period, provided such default is discovered within the time fixed by the bond, usually 6 months or a year after termination. Sec. 4. The underwriting of fidelity bonds. We now come to our principal object of determining how to underwrite these bonds, that is to say, of determining the circumstances under which they may be written and the circumstances under which they should be declined. We have seen that, whatever may be the particular acts covered by the bond, the essence of the risk or hazard is the chance that the applicant is dishonest and will, if he gets sufficient opportunity, take his employer's money. In underwriting these bonds, therefore, the essential thing is to be satisfied that the applicant is honest. Honesty is, however, only a relative term. A man who will not take his employer's money under some conditions, may do so under other conditions, so it is necessary to be satisfied not only that the applicant is reasonably honest, but that he probably will not, under the conditions that will exist in the particular case, take any of his employer's money. It is necessary, therefore, to consider an applicant for a fidelity bond from two standpoints, namely, first, his personality, whether, in the abstract, he is honest, and, second, the nature of the position he will occupy, whether, under the particular conditions that will exist, he can be depended upon to resist the temptation to take his employer's money. In discussing the problems of underwriting, it is not practicable to consider each position or class of positions. It is better to reduce the matter to general principles, that is to say, to point out those things which, when present in any case, tend to show that the employee cannot be depended upon to resist the temptation to take his employer's money. By considering each applicant in the light of these principles, the character and extent of the risk and the chances of loss may, with reasonable accuracy, be determined. In other words, the object will be to fix a standard by which the hazard or risk in any position may be judged. In order that the subject may be made as clear and specific as possible, an attempt will be made to distinguish between those things which it is essential to know, and those which it is merely desirable to know, and between those things which make a risk totally unacceptable and those which render it merely not first class. Sec. 5. The personality of the applicant, antecedents and environment. In attempting to determine the probable honesty of an applicant for a fidelity bond, it is important, in many cases, to consider his antecedents, and his early training and environment. Where a man has established a satisfactory record of his own, that record should be the sole guide in determining the manner of man he is, and in that event, it is not necessary to pay much attention to the matter of his ancestry or his early environment. But where the applicant is a young man who has not held responsible positions for as long as 5 years, and who therefore has not made a substantial record of his own, a consideration of his antecedents and early environment is essential. Although there are not many cases where this matter is of sufficient importance to justify the declining of the risk, there are only a few classes of persons whose descendants are prima facie unreliable, and the more important of these classes are, a. Negroes, who, as a class, have been found to be undesirable risks for a surety company, especially where they will handle money. b. The lower classes of foreigners, or even of Americans, particularly those who live in the slums of the large cities, where the atmosphere is not at all conducive to the development of a keen sense of moral responsibility. c. Those who have criminal records, or who have been guilty of such serious breaches of the moral law as to indicate that they have criminal instincts. d. Those who have very sporty tendencies, whose lives are immoral, who drink liquor freely, habitually play cards or otherwise gamble, who work little or none and spend money or contract debts almost regardless of income. The offspring of these classes may, and very often do, turn out to be fine men, but the percentage of failures is great enough to justify us in the conclusion that a surety company ought not to guarantee the fidelity of such a man until he has established his own record by serving in responsible positions for several years, with a clean record, and good habits. Sec. 6. Habits. The next thing to be considered is the character of the man himself, as it may be indicated by his habits, and in every case this matter should receive most careful investigation and consideration, as it is the most important element in determining the chance of loss. Surety companies, of course, cannot afford to judge applicants by puritanical standards, but there are certain habits which experience has shown are likely to lead to defalcations, and while the effect of these habits is well known to the average man and therefore need not be dwelt upon, it seems appropriate at this point to enumerate the more important ones, as follows. a. Speculating or gambling on the stock, grain or cotton exchange. This habit has led to very many and very large defalcations, and it is evident that a man who engages in this form of gambling should not be bonded. The bare fact that a man carries, or is suspected of carrying, a margin account with a broker, even though it may be small, is in my judgment, sufficient to warrant an underwriter in declining the risk. b. Card playing and similar forms of gambling are generally looked upon with disfavor by underwriters, but as a matter of fact, comparatively few defaults have been attributable to losses at cards, and it seems to me that it is only where a man plays with such frequency or for a large enough stake to materially affect his income, that his application should be declined. c. Extravagance and fast living. It is, of course, well known that this habit has led to many defaults, and underwriters look with disfavor upon applicants who have been in the habit of frequenting saloons, pool rooms and houses of ill fame, or associating with questionable characters of either sex, particularly if the salary of the applicant is small or apparently insufficient to warrant the expenditures which are likely to accompany these habits. It is, however, manifestly impossible to lay down any general rule as to what is and what is not proper conduct. The underwriter will determine in each case whether or not the applicant engages in these or similar practices to a sufficient extent as to be likely to call for expenditures beyond his income. If there is anything to indicate a reasonable probability, or even a reasonable possibility, that he will do so, the application should be declined. D. The excessive use of alcoholic liquors. This practice not only tends to undermine a man's normal fiber and to weaken his power to resist temptation, but it often accompanies or leads to extravagances or fast living. It often happens that heavy drinking is the only detrimental habit that will develop in the course of the investigation, but, in the absence of definite information to the contrary, it may fairly be assumed that such drinking is accompanied by the usual extravagances and indulgence. Hence, the excessive use of such liquors is of itself sufficient to warrant the declination of an application. Sec. 7. Financial condition. As a general proposition, an application for a fidelity bond should be considered and acted upon entirely apart from the financial condition of the applicant. That is to say, while financial strength is a very desirable qualification in an applicant, it is not an essential one. If an applicant is satisfactory in other respects, he may freely be accepted, although he may have no means other than his salary, and if his record and habits are bad, he should not be accepted, even though reputed to have money. However, where an applicant is known to have considerable money, slight imperfections in his habits do not necessarily make the risk undesirable. So also, if his parents or other near relatives are well-to-do, slight imperfections may be passed, as they may reasonably be expected to come to his rescue in case of trouble. While a man who has no financial resources may freely be accepted, caution must be exercised with the man who not only has nothing but who is in debt. Such a man will probably be called upon to use a part of his earnings to liquidate the debt and thereby decrease the amount to be devoted to the maintenance of himself and his family. And he may be so hard-pressed as to think it advisable to borrow from his employer in order to get rid of his creditor. If the debt happens to be due the employer, he may borrow with one hand to pay with the other, thus imposing upon the surety a liability for what is really a mere debt, and where he owes the employer, he is more likely to be compelled to use a part of his earnings to repay their loan, and in the event of default, it is probable that any credits to which he might be entitled by way of salary or otherwise would be consumed in liquidating the debt, rather than liquidating the liability of the surety. It is the same way with any property he might have. Therefore, unless the debt is secured by good collateral, it is better to avoid the man who is in debt, particularly if he is indebted to his employer. Sec. 8. The investigation. As we have seen, it is not always easy to get correct information as to the antecedents, environment, character and habits of an applicant. If we could, perhaps there would not be so much need for bonding companies. About the only sources from which it is practicable to get this information are the applicant himself, the persons to whom he refers, and his former employers. The applicant is not likely to give unfavorable information in regard to himself, so that this source of investigation is of little value. Likewise, it is hardly reasonable to expect that an applicant will refer to people who will intentionally give damaging information regarding him, so it is not well to put much dependence in bonds. I believe it will be as well to omit sending out the replies of the references, and in cases of very small reference letters. Where reference letters are sent out, the replies should be considered from at least 4 standpoints, namely, the standing of the reference, the extent of his acquaintance with the applicant, what he says, and what he fails to say. The standing of the references will have an important bearing upon the probable truth and accuracy of their statements, as well as upon the probable character and standing of the applicant. The man who can get a certificate of character, so to speak, from a bank president, who is intimately acquainted with him and his family, is likely to be infinitely a better risk than the man who refers to a saloon keeper, a bookmaker or a person having no particular standing. It is also important to note the extent of the acquaintance of the reference with the applicant. The fact that a man does not refer to persons who know him well is a suspicious circumstance, for almost any man, if he wishes to, can refer to men who do know him well, and the fact that he does not do so may be a sign that those who are well acquainted with him would probably not give a favorable opinion. It is unnecessary to call attention to the importance of weighing carefully any damaging information given by a reference, for such information may be assumed to be true. But it is also important to note any apparent evasion or omission to answer the questions asked. There are many men who will not deliberately give a false answer to questions of this kind but who will evade them or omit to answer them. This probably results from a natural disinclination to speak ill of others, particularly one's friends. But, in making investigations of this kind, surety companies ought to have the whole truth, and if there is any indication that they are not getting it, they should move cautiously. The really valuable information concerning an applicant is to be had from his former employers, for a good clean record covering continuous service for as much as 10 years warrants the assumption that, in the absence of extraordinary opportunities and temptations, the applicant will continue to be honest, and conversely, if he has been dishonest in the past, he is not to be trusted for the future. In view of the importance of obtaining the record of the past employment of an applicant, it is essential that he be required to give the name and address of all his employers during the preceding 10 years. In order to warrant the acceptance of the risk, it is essential that, if possible, a reply be obtained from each of these employers, confirming the period of the employment as well as giving the applicant a favorable report. If a reply be not obtained, acceptance of the risk should be withheld until a satisfactory explanation is made, such as that the employer is dead or out of business and his whereabouts unknown. When a situation like this develops, caution must be exercised and a very careful investigation made, as the name of a fictitious employer may have been given to conceal the real employer, who had an unsatisfactory experience with the applicant. Given a complete record of the employment of an applicant for as much as 10 years, and a showing that that record is clean and free from any suspicion of dishonesty, and that so far as the former employers know, applicant's habits are good, then I think it fair to assume, in the absence of extraordinary opportunities and temptations in the present employment, that he may be depended upon to be honest. In that event, the replies of the references are really of little moment. Sec. 9. The nature of the position. In general, we have been discussing the matter of how to determine whether or not an applicant for a fidelity bond is honest. It has been said, however, that there are no absolutely honest human beings. The cynical saying that every man has his price expresses the idea. While most people are unwilling to give credence to any such thought, yet it is a well-known fact that the question, whether or not an employee is likely to take his employer's money, does depend in a measure upon the opportunities he will have and the temptations to which he will be subject, and it is manifest that it is not possible to determine the hazard to which the surety for an employee will be subject unless the opportunities, temptations and liabilities incident to the position are ascertained and unless their effect upon the risk is known. The opportunities, temptations and liabilities are usually ascertained by requiring the employer to answer certain questions concerning the duties and liabilities of the applicant and the checks and audits that will be enforced, and it will be my purpose in the succeeding pages to discuss the possible opportunities, temptations and liabilities of employees, with a view of determining their effect upon the risk of the surety. Sec. 10. Opportunities. The amount of money to be handled. It is of course manifest that the risk bears some relation to the amount of money that will come into the hands of the employee, and the amount that will be on hand at one time. In the case of employees in the main office of the employer, the amount of money to be handled is not an important consideration, as it may be assumed that the risk is in proportion to the amount of the bond. But in the case of employees who are away from the main office, agents, branch managers, solicitors, collectors and the like, it is important not only to consider the amount of money likely to be on hand at any one time, but also to see that they are required, at frequent intervals, to turn in all money received, so that they will not, in ordinary course of business, have on hand a large sum. There may be nothing to prevent them from neglecting to account for some of the money that has come into their hands, but the fact that an accounting is necessary has a restraining effect, and accountings should be required not less than once a month, and in the case of such employees as drivers for laundries, and the like, daily accounting should be made. These requirements should be a condition precedent to the issuance of the bond. Sec. 11. Extent of control over employer's money. Where the money is to be handled solely by the applicant and where he could take it without the knowledge or consent of any other person, the opportunity is practically unlimited, and it is lessened to the extent that it is necessary for him to obtain the consent or collusion of another, or to bring a defalcation to the attention of another. Where, for example, one man has exclusive control of an office and personally handles the cash, or has such control over it that no one else would observe or take note of a defalcation, where a man has the right, without counter-signature, to check against the employer's bank account, or to draw on the employer, where a man is acting as both bookkeeper and cashier so that he could himself doctor the books and cover up his shortage, where a man is on the road having the custody of his employer's goods, or collecting or dispersing his employer's funds. In all these cases, the opportunities are practically unlimited, and the only safeguard is to audit very frequently the books and accounts of the employee and to verify the cash on hand and outstanding. It is not necessary to decline all applications where the opportunities are thus unlimited, but it is necessary to be sure that the personality of the applicant is up to the highest standard, and that frequent audits will be made. Where, on the other hand, though a man has control over an office, yet the funds are actually handled, and the books kept, by another, so that, barring secret personal collections made outside of his regular duties, no money would come into his hands, where counter-signature is necessary on checks and drafts, and where one person is cashier and another, bookkeeper, so that neither could easily get any money without the collusion of the other, the risk is lessened. In the case of collectors and other traveling men, it is almost impossible to limit their control over the funds or property in their hands, and, as we shall see, the risk on such employees is very great and can be limited only by frequent audits. A promise by the employer to make frequent and thorough audits should be a condition precedent to the execution of bonds for such employees, and even then they can be issued only when the conditions of the employment are satisfactory. Sec. 12. Opportunity to conceal shortage. A man may have abundant opportunity to take his employer's money, but he is not likely to do so, if it is certain that the defalcation will be discovered immediately or at the end of a few weeks. It is of the utmost importance therefore, in cases where the opportunity is great, to require the employer to promise to make very frequent, as well as efficient, audits of the books and accounts of the employees and to verify the cash on hand or outstanding. Such audits are likely to result in the discovery of a shortage before it has gone very far, as defaulters usually begin by taking small amounts, and the knowledge that such audits are to be made is likely to have the effect of deterring the employees from committing any default. Competition has driven the surety companies, in the case of banks and a few other high-grade institutions, to waive the requirement for periodical audits. Indeed, in some cases, employers' statements are waived altogether. This is done on the assumption that a careful supervision over the employees will be exercised, that, in any event, the opportunities are rather limited, and that audits will in fact be made at least once a year. In most cases, it is not deemed proper, or consistent with reasonable prudence, to omit to require periodical audits. Audits made in accordance with the following schedule will generally be satisfactory and should be required. A. The main office should be audited by an outside expert accountant once a year. B. Agents and branch managers once in 6 months, and all outstanding accounts should be verified. C. Collectors, as we have seen, should be required to account at least once a month, and as soon as an account is in arrears, a bill should be sent direct by the employer to the customer. D. Drivers who collect should be required to account daily, and the employer should be required to send bills directly to customers who are in arrears. The employer ought in all cases to be required to give the surety prompt notice of the discovery of a default or probable default on the part of an employee, as otherwise the audit and checks would be of little value to the surety, and the employer could retain in his service a man who was known to be a defaulter, or could deliberately permit the employee to escape and nevertheless have the protection of the surety company. Sec. 13. temptations. In general, opportunities may exist, but if there is no strong incentive or inducement to take the employer's money, an employee is not likely to do so, as normal human beings, in the absence of special temptations, are not prone to take property that does not belong to them. We have already discussed, under the title of the personality of the applicant, the strong temptation that may result from gambling, speculating, extravagance and fast living. It is important also, to consider any special inducement or temptation peculiar to the particular position. The more important of the temptations, which are shown by the records of surety companies to have an influence on the risk, will be indicated, so that the underwriter may, in the light of the employer's statement, look out for them in each case and be governed accordingly. Sec. 14. Inadequate compensation. One of the temptations that may be inherent in a particular position is that of inadequate salary. We are not now referring to the inadequacy that may result from extravagance or fast living. That has already been considered. We are now referring to the case of a man who is forced to accept a position, the salary of which is not actually sufficient to enable him to support those dependent upon him in the manner to which they have been accustomed. The author recalls a case where a man was the manager of a branch store of a large tailoring concern, receiving a salary of $18 per week. Under some circumstances, this might have been sufficient, but he was about 40 years of age and had held a better position. He had a wife and several children dependent upon him for support, and he was expected to dress well and keep up appearances in order to sell goods. Though he lived modestly in a small apartment, his wife doing all the housework, and though they spent practically nothing on amusements, he found at the end of a certain week, that he did not have quite enough to pay his household expenses. So he took out of the cash drawer, enough to make up the deficiency, intending to pay it back with next week's salary. Instead of paying it back, he found it necessary to take more. And this practice continued, despite every economy he could reasonably practice, until the traveling auditor, in making his semi-annual trip, discovered the shortage and discharged him. Another case was where a young man holding a respectable position in an office, in a large city, with a salary of $65 per month decided to marry. He found it impossible, though he lived modestly, to pay his necessary expenses, and having access to his employer's money, took a little to make up the deficiency. The practice continued until, at the end of about 6 months, the shortage was discovered. Instances could be multiplied, but these are sufficient to make it clear that, though a man may have a good record, may have no bad habits and may live modestly, yet if he is not making enough for his needs, considering his station in life and the number of persons dependent upon him for support, he is not a good risk. What is an adequate salary will of course depend upon the facts and circumstances of each case, and no general rule can be made. Sec. 15. Where amount of compensation varies. This matter of compensation is particularly important when the employee is paid by commissions so that the amount of income is indefinite or uncertain, varying with the amount of business done. When such a man has had a bad month and does not earn the amount he has been in the habit of spending, the temptation to assume that the next month's business will be greater and to anticipate the income from the expected increase by borrowing a little from the employer is very great, and this class of bonds should on this account be regarded as hazardous. The fact that such employees cannot generally be punished for taking their employer's money is an additional, and very serious hazard, which will be referred to in the next section. Sec. 16. Where there is no power in the state to punish a defaulter. Most men are deterred from taking property that does not belong to them by their own consciences, others, by the fear of public disapproval, but there are still others who are not deterred by anything short of the fear of punishment. Therefore the reputation for relentless prosecution of unfaithful bonded employees, which the bonding companies have gained, is believed to have materially lessened the number of such unfaithful employees, and impending imprisonment has induced the relatives of many a defaulting employee to come to his rescue. Accordingly it was formerly thought necessary to the proper conduct of the surety business to impose a condition that, in event of a default, involving the commission of a crime, the employer would lay information before a proper officer and verify the same as required by law, to the end that a warrant for the arrest of the employee might be issued. Recently the companies have, in particular cases, been waiving this requirement, but in view of the advantages often to be derived from the prompt arrest of a defaulter, surety companies ought to be slow to do so, although, of course, it may be good business policy where the volume of business is large, and where, as a matter of fact, the employer intends to cause the arrest of any of his employees who may commit criminal acts. In due season, the surety company might be able to get the information before the proper authorities. But in the meantime, the defaulter may have absconded. Where the bond covers only larceny and embezzlement, such a provision, in theory at least, imposes upon the employer the obligation of laying the information before the authorities or abandoning his claim, and amounts to a reasonable assurance that the surety will not be held for a default unless the defaulter can and will be prosecuted. Where the broader form of bond is issued, the employer, notwithstanding such a provision, may decline to swear out the warrant for the arrest and nevertheless will not be estopped from contending that the act comes within the scope of the bond. It is evident from what has been said that if, notwithstanding such a provision in the bond, an unfaithful employee cannot be prosecuted, the chance of loss on the part of the surety is increased. And it is a well-established principle of the law of some of the states that, where an employee receives money for joint account of himself and his employer, that is, where the employee is entitled to a percentage of the money so received, he cannot be punished for failing to turn over to the employer the latter's share of the money. The employer and employee are regarded as partners or tenants in common of the fund, and it is not a crime for partner or tenant in common to take and use the common property to the exclusion of the other partner. The remedy of the other partner is a civil action for the division of the common property and for the recovery of his share. So, in the states where this rule prevails, an agent or other employee, who receives his compensation in the shape of commissions on money collected may with impunity, so far as punishment is concerned, convert the employer's share of the money so collected, and consequently such risks are not desirable. So far as this phase of the risk is concerned, it would seem to make no difference whether the entire compensation of the employee is paid by commissions, or part of it as salary and part as commissions. In either event, he would have an undivided interest in all the money that would come into his hands, and therefore the rule would seem to be applicable. While business policy will often require the taking of one or more employees on commission, along with a number of others on salary, yet, as a general rule, such employees are not desirable risks for a surety company, and they should not be accepted unless they measure up to a very high standard or have very considerable financial responsibility. Sec. 17. Liabilities of employee. In general, we have seen that the surety on a fidelity bond is liable only for loss resulting from certain specified acts on the part of the employee, but in underwriting these bonds, it is well to take into consideration any extraordinary liabilities that may be incident to the position, as they may have a material effect upon the risk of the surety. Such extraordinary liabilities usually result from the terms of the contract of employment, and attention is directed to the matter to the end that this feature may not be overlooked. One or two of the more important liabilities will be treated in some detail. Sec. 18. Liability for stock shortage. Employees who have the custody of merchandise away from the main office of the employer are generally charged with the quantity sent to them, and are required periodically to account for the amount shown by the employer's books to have been received. If they cannot satisfactorily account for or explain the disappearance of any part of the merchandise, they will be held liable for that amount. Managers of coal and lumber yards are typical examples. Notwithstanding the surety cannot be legally held for loss that does not result from an actual misappropriation, bonds of this kind are generally unsatisfactory. Merchandise, when delivered in wholesale quantities, and retailed, is very apt to run short to a certain extent, and some of it may be taken by third persons. It is therefore difficult in some cases to tell whether the shortage represents a misappropriation or not, and the surety is likely to be called on to make good a shortage where the principal denies having made a defalcation, and when there is every reason to believe he is telling the truth. While the surety may not be held liable, there is apt to be some litigation and expense, resulting perhaps in a compromise settlement. In case of an admitted defalcation, claim is likely to be made for the whole shortage, no credit being allowed for the natural or inevitable shortage. Even if the employer attempts to recover from the surety only the actual defalcation, he will likely take advantage of any set-offs, by way of salary or otherwise, and exhaust the resources of the employee in making up the shortage, leaving the surety to pay the defalcation without any chance of reimbursement from the principal. In such cases the bond should not be written unless the employer has established a reputation for fair dealing, and the merchandise is reasonably well protected from possible depredations by third persons, or unless the applicant has some considerable financial strength. However, where there are a few such employees on a large schedule, it may be reasonably prudent to accept them along with the rest. Sec. 19. Liability for uncollected accounts. In many cases, agents, branch managers and the like are, by their contracts with their employers, liable for all, or a certain percentage, of the bad bills or uncollected accounts. While the surety is liable only for such money as actually comes into the hands of the employee and is misappropriated by him, yet the risk is undesirable because a. The liability for uncollected accounts imposes a heavy burden upon the principal, and may decrease his net earnings to such an extent that there will be the temptation that usually results from inadequate or uncertain earnings. B. In event of default, the employer will likely take advantage of any set-offs by way of salary or otherwise and exhaust the resources of the principal in making up the liability for uncollected accounts, leaving the surety to make up the defalcation with no chance of reimbursement. In such cases, the bond should not be written unless the applicant is quite strong financially, undoubtedly strong enough to take care of any reasonably possible liability for uncollected accounts without impairing his means of support.